lakhs of cases have been filed in the courts across the country, that is magistrate courts or additional chief metropolitan courts or chief metropolitan courts, by the persons who have received the checks and the checks were bounced. Then immediately they have filed the check bounce cases which are now pending. Recently Supreme Court had happened to deal with a case where the accused has given a check and that was bounced. When the complainant, that is exports company, Kumar Exports Company, had filed the check bounce case against the accused, the trial court held that the accused has given the check in discharge of debt which was legal and therefore convicted the accused. Taking this conviction in appeal by this particular individual before High Court, he filed a criminal revision case. Then High Court has reversed the judgment of trial court and said that the findings of the lower trial court were not correct and therefore discharged or acquitted the accused person who was found guilty under section 138 of Negotiable Instruments Act. Now thereafter this Kumar Exports, the complainant, had preferred an appeal special leave petition criminal before the Supreme Court of India, and Supreme Court of India has very clearly held that section 139 he will go in favor of the complainant, that is, as long as the accused has not denied his signature on the check or has not denied the debt that was legally dischargeable by him towards the complainant, it will be presumed that the accused has given check and there was liability existing. Therefore, the Supreme Court while reversing the judgment of the High Court has held that the accused has the trial court has rightly convicted the accused and trial court's conviction which was awarded against the accused was proper. At the same time, the Supreme Court has also found fault with the order passed by the High Court. It has given a common signal to all the high courts of the country saying that the criminal revision is not a particular relief granting section which is available to all the accused persons or the complainants to immediately rush to the High Court under the particular provision 401 CRPC. It said that as long as there is no perversity in the order of the trial court, the High Courts cannot entertain the applications under revision casually, as such entertainment of revision will amount to expressing a different view. So the revision is not for expressing a different view on the judgment rendered by the lower trial court. That is why Supreme Court said that High Courts must be very slow in entertaining these criminal revisions. So what we get from the Supreme Court's judgment in case of Kumar Exports versus this particular accused individual is that number one, section 139 is a section of law which says presumption. Presumption means when an accused has signed the check and delivered the check to the complainant, it will be presumed that the signature available on the check is that of the accused. And second presumption is that there is a legally dischargeable debt that is existing towards this particular accused, and when he had given the check will also carry the presumption that there is a debt that is legal and that legally dischargeable debt has been existing and the accused has rightly issued the check. Therefore, in the cross examination or in the 330 examination, if the accused does not elicit a contrary evidence that the check was not issued by him, that there was no legally dischargeable debt, that his signature was not available on the signature the check form, then it will be presumed that accused has committed the guilt or accused is liable for the guilt. Therefore, these 138 cases one must be very careful, and going by the judgment rendered in Kishan Rao versus this particular judgment, Kishan Rao versus Shankara Gowda, 2nd July 2018, this judgment has been rendered. So viewers, if necessary, they may refer to this judgment.